Good afternoon, everyone. Welcome to the 13th talk in the Only One Theme talk series. And this is the second wave of this talk series. This series, as you may be aware, is hosted by TechX.in Vertical at Venture Center. Today's topic is only deciding inventorship for patents. And the talk is going to be delivered by Dr. Srividya Ravi. Let me briefly introduce Srividya. Srividya brings over 15 years more of experience in intellectual property rights, following a decade in pharmaceuticals where she focused on product development and quality assurance. Currently, she is leading the Pune operations at Gnanlex Hermeneutics Pvt Ltd. Srividya holds a doctoral degree in health sciences, a master's in pharmaceutical sciences, and a postgraduate diploma in patents law. She is recognized as a leading resource in pharmaceutical regulatory sciences and IPRs, where she speaks at global workshops and training sessions. Srividya has trained patent agents, patent examiners from various countries and consulted for the World Health Organization on COVID-related technologies. With this brief introduction, welcome Srividya to the session and handing over the session to you.
Thanks, Mugdha. Thank you for that warm introduction. Good evening to all participants, and a big warm thank you to TechX and Venture Center for giving me this opportunity to speak on a fairly unique subject. An entire talk devoted to deciding inventorship is usually not a session that I take, but I think it's a very relevant topic. And considering there is so many different entities who are applying for patents these days, the Indian Patent Office is flooded with applications from individuals, startups, SMEs, large corporations, people who collaborate across institutes and universities and so on and so forth. So, considering the current scenario, I think it was a very relevant topic that was picked up for this only one theme. And I am thankful for having used this opportunity, given this opportunity, sorry, to learn about this subject a little more. And that is what I intend to share with all of you over the next hour or so. So if you allow me to share screen.
You can check, you can share screen here.
Yeah. Okay. Visible now?
Yeah.
Yeah.
So
okay.
do you want to also switch on your video if you have bandwidth?
Yeah, I think I should be able to. Just give me a minute. Yeah, is that okay?
Yeah. We are not able. Yeah, we are not still able to see you, Srividya.
Oh, is it?
Yeah.
Okay. Just a moment. I think there's some problem the moment I try to do that. So I think I'll just leave it at this if you don't mind.
Yeah, that's okay.
Okay.
Just probably need to go full screen.
Yeah. Just my screen is going into all hang mode if I do something now. So
yeah, all right. Yeah, we can see it full screen now. Yeah.
Yeah, it's transitioning.
Yeah, it is also transitioning.
Okay, fine. All right. So we'll begin the talk with basically understanding, who an inventor is, and not yet looking at the the legal implications of the definition of an inventor, we just begin by understanding, what to a common man an inventor means, or what the dictionary defines an inventor as. So, very simply put, you could just say it is someone who has invented something. But the moment you say invented, you need to define what then is an invention or what is a process of inventing. So then we, if we dwell into the definition of invent, it is the act of bringing ideas and objects together in a way that you create something new, something that did not exist before. So the act of inventing is an act of creation, an act of creating something that did not exist before. And um, therefore, the inventor is basically a creator. He is someone who designs something that did not exist before today. And this act of creation is therefore linked with intellectual property rights, because IPRs basically cover and protect creations through the different forms and the different acts that are associated with those different forms. So, so what we are looking at is that you're looking at someone who's producing something, which can be put to use by humanity. So it can be just a useful device or a simple useful process, of course, for the first time, because it should not have existed before. And he is doing this through the process of bringing ingenious, thoughtful processes and the exercise of his imagination, and then reducing it to practice by way of experimentation. So it is basically you're looking at someone who realizes that there is a problem, there is a situation which demands a solution, and this person who is the inventor is actually the person who conceives or who conceptualizes that particular solution to the problem. So you are talking of ingenious thinking, imagination, everything put together with experiments, and somebody exercising their intellectual capacities to conceive a problem and propose a solution. So at every stage of the process of invention, you are having a human intervention. You are having intellectual capabilities being put to use, ingenious thinking, and thus arriving at a solution to the particular problem. So you have, if many of you may be practitioners in the field of IPRs, and you must have heard of this problem solution approach. So that is what inventions are all about. Any
Srividya, are you still in the call? Okay. Just hold on, we'll just check with her. Speaker is joining in 2 minutes. Yeah. Hi, Srividya. You're back.
Yeah, am I back? All
Yeah.
right.
Yeah.
Let me share screen. Yeah.
Yeah, we can see your screen.
Yeah, just a minute. I am trying to go back to the slide that I was in.
Yeah,
Okay, can you see this
yeah,
meaning of the inventor? I think you heard me throughout this, right?
yeah, yeah. We were hearing this slide.
All
Yes.
right, fine. So now I move over to the next slide.
Yeah,
And all right, sorry about that.
yeah,
Uh, so going ahead, we are looking first at various stakeholders who are involved in the process of invention. Okay, we try and understand each of these different entities who are involved, their particular roles, and what is their contribution towards the invention. So you obviously first have the inventor who comes up with this creative idea or the solution to the problem that he is facing, and with him there could be an entity called the co-inventor or the joint inventor, who also is probably contributing intellectually to the idea. There could also be, others such as, facilitators who are involved in this process. It's either the company where you're working, the organization for which you work. So it could be the industry, which is providing you all the facilities and the funds to conduct the research, or the college where you are teaching, where you also conduct your research, where you're utilizing the laboratory facilities and so on and so forth. It could also be, instead of a college, a university, or it could even be some of your superiors. One among them could be the principal of your college, or it could be the head of your particular department or section in the industry, or it could even be the owner of your organization, which could be, applicable to even the company or the college where you're working. So these are the people who are basically, in charge or responsible for providing you the facilities to conduct the invention. And their role is probably just that, in the sense that they are the facilitators. And then you probably are doing collaborative research. So you have a collaborator, you probably have a co-inventor there, because the collaborator is also intellectually contributing to the invention, or the collaborator is only to the extent that either their facilities are used for you to conduct some particular set of experiments, or they are on a contractual paid basis with your organization to basically do some parts of the invention at their end, because they have the facilities to do it. Maybe they have a particular equipment, or they have a particular device which is needed by you, any such thing. For example, if there is an owner of an animal house and you need to conduct some animal studies, so you're basically going to use your collaborators facilities to conduct the animal study. So he'll be, give you the guinea pigs that you need. He'll give you the staff who will be able to work on these guinea pigs, while you are the one who is looking at the protocol to do those tests, and then you will be evaluating the results and arriving at the conclusions. So the collaborator could be of either nature, maybe somebody contributing to the idea, or maybe somebody just providing you services, and especially on a paid basis. So then you also, which falls into the also the realm of contractual working. So you could have either laboratory that services you, or you could have project assistants or laboratory assistants who are on paid basis and giving you the required services. So these are some of the stakeholders in this entire ecosystem, and within this you need to identify who is the inventor and who is not, and so who has contributed to the conception of the, or conceptualization of the solution to the problem, and who has merely provided you services or facilities, and who therefore have not been involved in the creative part of the invention. So with this background, we'll plunge into the legal aspects, which will, then help us arrive at who could be possible inventors and who could be having the inventorship in patent applications. So, what do the law say? So, we are predominantly going to look at, of course, the Indian laws, but also on a comparative note with the the United States and the European regulations. Mainly because we file most in these domains; they're the most attractive markets. Having said that, there are other, of course, geographies which you as inventors may be interested in. um, Once we go through these three countries or regions, you will realize that inventorship by definition itself varies from country to country. The national laws are a little different, and the rights vested on the inventor is a little different from country to country, and therefore it is best to understand the local laws of the country where you're seeking patent rights. So the examples are merely to actually demonstrate the fact that it is best understood by going or reviewing the laws applicable in individual countries. So if you look at India, India basically, is kind of giving an exclusion statement. They say does not include either the first importer. So the true and first inventor is not the first importer of the invention into the country. So if there is an entity which is merely bringing in some patented goods into the country for reasons of testing or doing further product development or even marketing or selling, they will not be considered the true and first inventor. Alternately, a person to whom an invention is first communicated from outside India will also not be the true and first inventor. So, merely receiving a communication or merely importing a patented goods does not qualify a person to be a true and first inventor. This is how the Indian Patent Act has defined this particular terminology. And further, the Act goes on to say state who are eligible to apply for patents. So there they say the true and first inventor is eligible. So these two entities cannot apply. There can be other ones. There can be the assignee or true or of the true or first inventor. So assigning, what does assigning mean? Assigning is the process of transferring your rights from one entity to another. So in this case, if you are the true and first inventor and you give up your rights and assign it, say to your company for which you're working, or to the university where you are serving, then the university or the company is the assignee for the patent rights that you hold. So the true or first inventor or the assignee of the true or first inventor or the legal representative of a deceased person who just before death was entitled to make such an application. So the if there is the death of a true or first inventor, then his legal representative is also eligible to apply for patents in India. Okay. Now, how is this established in the Indian process? Along with your patent application, which is called the Form 2, where you actually describe what your invention is, you also need to submit the Form 1, where there is a declaration of inventorship. So the true and first inventors of the invention are actually listed out in the form that you submit to the Indian Patent Office. And this is further confirmed. The list of inventors is further confirmed by the submission of Form 5. Both these forms are mandatory for your patent application to be completed, the process of patent application to be completed. And Form 5 is kind of a confirmatory note over what is listed in Form 1. So this is where there is a written communication from the person who is applying for patent protection for an invention, stating that XYZ or whatever names that you're listing are the true and first inventors of the invention for which the patent protection is being sought. Okay, so this is how the Indian system progresses. And basically, when you say what are the rights you're accruing out of being the true and first inventor is, so if there is a product patent, then you can of course prevent others from doing the 5 typical acts for which patent protection is sought, that is making, using, offering for sale, selling, or importing that particular product. And if it is a process, then either you don't perform that process, or you cannot do these 5 acts on the product that derives out of those particular process for which you are applying a patent protection. So these are the rights that a patentee holds, and the reason why I particularly elaborated on this aspect is that the true and first inventor can also be the holder of the rights. As I just told you can either assign the rights to someone, or there is a concept of what is called an applicant in India. Okay, so the inventor is always a natural person who conceives or conceptualizes the invention, whereas an applicant can either be a natural person or an applicant will be an entity. So it could be either an industry, a corporation, a trust, a university, a college, a small or medium or large enterprise. It could be any of these. Okay. So since the possibility of a natural person being both the true and first inventor as well as the applicant exists, therefore it is essential for us to realize what are the rights that are vested on the patentee, and therefore this has been elaborated at this stage. Now let's look at how the US law looks at an inventorship. Okay, the US is a little more elaborate, and in fact, it is probably giving the best explanation as to who could be an inventor. So what the US law says is the one who conceived the invention, he could also have reduced it to practice, but he should have conceived the invention, and it is not the one who just reduced it to practice. Okay. Now, when we talk of conceptualization or conceiving of the invention, we are talking of the process of creativity and the process of exercising one's intellectual capabilities. Now, what do you mean by reduce to practice? Okay, let's try and understand this also just for the sake of clarity. When you say reduce to practice, what it means is the experiments that are designed by the inventor, okay, the true and first inventor, who actually, as we said, is using his intellectual capabilities. He designs the experiments, okay, he decides what is to be done, what is the solution to the problem that you're facing. So all that is put on paper, and then he writes a protocol for the experiments to be done. And then there are certain individuals who are involved in this process, but who just practice what the inventor is put down on paper. So what do you mean by just practice? What you mean is they conduct the experiments, okay? They note down the observations and they go back and give it to the inventor, okay? So they are basically either people who are working in the laboratories or people who are conducting the experiments. So these are people who are reducing the concept to practice. So they are actually doing the bench work. Okay, so such people who are doing just the bench work do not qualify to be an inventor according to the US laws. What the law is very clear about is that there is no requirement that the inventor be the one to reduce the invention to practice. Okay, so he need not conduct the experiments himself, so long as the reduction to practice was done on his behalf. So anybody working under him, anybody who is part of the team, anybody who is collaborating, anybody who is contractually arranged to do those experiments can all do it because they're all doing it on his behalf. So it is not necessary the inventor himself has to go to the laboratory and conduct all the experiments, observe what are the outcomes, and arrive at the conclusions. All he has to do is to put in his intellectual capabilities, and somebody else can do all the bench work. So the inventors need not personally construct and test their invention. Okay, so it can be done by somebody else. A non-inventor's work was merely that of a skilled mechanic carrying out the details of a plan devised by another. Okay, so those who are merely working, or carrying out the details of a plan, such as that of a mechanic, would then obviously qualify to be a non-inventor. So the US Act is fairly much clear than the Indian definition. And they very clearly said that there has to be somebody who has conceptualized the entire invention, and that person is a true and first inventor. The US Act is very clear about the fact that an invention could be done by more than one person. A single invention could be worked by more than one person, both at the conceptual stage as well as at the reduction to practice stage. So you can have what are called joint or co-inventorships. Okay, so when it is made by two persons jointly, when the invention is conducted by more than one person jointly, they can apply for the patent jointly and they will be named as co-inventors. Now, there are certain conditions which are very clearly elaborated in the US Act, which gives us also a lot of clarity on the particular conditions that enable you to determine joint co-inventorship. So what they say is inventors may apply for a patent jointly even though they did not physically work together or at the same time. So you don't have to be in the same laboratory. You don't have to be working at the same time. You could be even, across the globe. You could be two collaborators in two different countries, and you're not, physically present at the same time. But once you have a collaboration arrangement, and if you're, contributing conceptually, then you can be joint inventors. You can be joint inventors even if each did not make the same type or the same amount of contribution to the invention. Okay, so somebody did a very small contribution, somebody had a major contribution. Okay, in spite of that, both would be co-inventors. Okay, so maybe somebody did, a predominant amount of intellectual input they put in, but somebody just merely added something very, not so much in terms of quantity, but maybe a very small contribution, but still that person would be acknowledged as a co-inventor or a joint inventor. And again, each did not make a contribution to the subject matter of every claim of the patent. Okay, so you need not have contributed to every claim in a patent application. Say a patent application has 10 claims, you have contributed to claim 1, 3, and 7. Somebody else has only contributed to claim number 9. Yet you both will be co-inventors. Okay, it doesn't matter that somebody contributed merely to one claim or one aspect of a claim. You would still qualify as a co-inventor. Okay, so it doesn't matter where you are located, when you are working, the amount or the type of contribution you have done, or whether your contribution was equal or unequal in terms of the number of claims in a patent application. The inventive entity for a particular application is based on some contribution to at least one of the claims made by each of the named joint inventors. So that is all it requires, to have contributed to at least one of the claims. Okay. The moment you make such a contribution, you qualify yourself as a joint inventor or a co-inventor. Okay. Now the US Act is also very clear that the inventor and the co or the joint inventor are natural persons. Okay, so you are still talking of the same creative inputs that come from the ingenuity or the imagination of the human mind. Going further, we look at what the European Patent Convention states. The European Patent Convention is basically applied across all the members of the European Union. So it is applicable to over 30 countries. And there are certain things to remember when you're talking of the application of the EPC as well, which we'll come to shortly. However, let's first try and understand what the EPC states with regard to inventor and inventorship. So here what we are looking at is, they say the inventor is a person who created the invention by their own creative activity. So it's very, very clear again, very simply put, but you have to have a creative activity, and it is, their own creative activity which it is contributing to. And the inventor should be a human being or a legal person. The inventor has rights, as we saw in India also, the inventor has rights. Similarly, the EPC has also vested rights on the inventor. It is also, of course, also there in the US Act. And, there are rights to the property as well as the rights to transfer the property. There is a lot of importance laid down in the European Patent Convention, with regard to identifying the inventor of an invention. Okay, this is true again in the US Act also. In fact, they say that if you've been not able to, find an inventor, then you should actually have records to say that you made an effort to find them. And in spite of that, if you could not, only then can you apply for a patent without the inclusion of that particular inventor's name. Okay, so correct identification of inventors and the inclusion of only those who are inventors in the forms that you fill to the with the patent application is very crucial across all geographies. So the right in the European system, of course, belongs to the first and the true inventor, or to the successors of his title. And if there are multiple inventors, so EPC also recognizes co-inventorship or joint inventorship. Okay, and the rights are shared in that case. Accurate inventorship ensures that the rightful inventors receive credit and benefits from the patent. Now, this is very important because, but if you have government schemes, or if you have your industry has schemes where they say the shares of the patent has to be split with the applicant in such a proportion and with the inventors in a certain proportion, then it is only correct that the right inventors are named in the patent application and they receive the due credit and the benefits. So not only in terms of rewards in that sense, it is also credit in terms of their intellectual contribution. So the right inventors being named so that they are credited to be inventors is also very important, and the EPC has actually emphasized this fact. Having said all this, okay, as I said earlier, there is a lot of local laws or national laws amongst the European Union countries, which need to be kept in mind when you're determining or putting in the list of inventors in your patent application. So moving on further, now, how do you determine who is it?
There was one question in the chat box. Do you want to take it right now or later on?
Yeah, I don't mind. I wasn't looking at the chat box. I'm sorry.
No, no,
Yeah,
I'm
please go ahead,
wondering.
Mamta.
Yeah. So Vidula is asking, is a patent assignment independent of inventorship? How will it affect in case of a legal issue?
Okay. Yes, patent assignment is independent of inventorship. Vidula, my answer will be in twofold here. Basically, I'll first like to elaborate on the US system. In the US system, the the process is that the inventor only applies for the patent. Okay, patent protection. The application is always filed by the true and first inventor or his joint inventors. And then there is what is called the assigning of the rights to the assignee. Okay, so the entity whom we call applicant in India, that means the entity who holds the rights, which, as I said earlier, can either be a natural person or it can be a commercial entity or educational organization or a trust or whatever. Such an entity in the US is called the assignee, and the true and the first inventor assigns his rights to the assignee. So that is done through a declaration which is filed in the US Patent Office. Okay, so there is an assignment declaration that is signed by the true and first inventors. As against this, in the Indian system, okay, you have Form 1 where you actually list the inventors. So you will put your joint and co-inventors also there. And you also have to write who the applicant is. So the applicant could be the inventor, one of the inventors, and an entity, or purely an entity who is not a natural person. So it can be a combination of any of these. So in the Indian system, upfront you're stating who is the applicant and who is the inventor, and then as against in the US system where the true and first inventor files for the patent and then assigns his rights to the assignee. Okay, so if you're looking at who has the rights, because the true and first inventor also assigns the rights in the US system, the rights eventually rest only with the applicant or the assignee. I hope I've answered your question, Vidya.
Yes, Vidya.
Yeah, thank you so much. All right, so moving on, is there a test for inventorship? Now, how do you determine? Now that we have understood who an inventor is, how do we determine who the inventor is, because you've had so many people working on your project. Maybe you had a project going on for 2 or 3 years. You had somebody who came in briefly. Maybe there was a project assistant for 1 year. He left and went. Another one joined, and then you have a few postdoc fellows working with you on a particular project. Then you also have your colleagues, who are in your laboratory, and then you have your bosses, you have the HODs, and with so many people involved, how do you determine who will be the inventor in a particular patent application? So the natural thing was to go and look to see if there is a test, and then you apply the test, whatever are the results that gets included in your inventorship forms. But however, the Indian Act does not specify any such thing. While the US says, anybody who is involved in the conceptualization of at least one claim will be get included as the inventor. And the EP says it's a national loss, and eventually the claims that are granted, because sometimes over a period of the prosecution that the patent application undergoes, some claims will be dropped, or some claims will be deleted, or some claims may not be chosen to go ahead with. And if that is the case, then you will have a difference in the inventorship from the stage of application to the stage of grant. However, having said all this, while we don't have a clear-cut test, they do recognize the fact that co-inventorship is acceptable across all countries. So then what I have tried and done towards the end of this talk is to show you what is the best practice in determining inventorship, and how to record it, and how to eventually arrive at your inventor list. So we'll perform that test towards the end of the talk, while I'll move on to a certain few other concepts that we need to understand before we arrive at that particular test. Okay. So if we are talking of the rights of the co or the joint inventors, because we know what the rights of the inventors are, but then if there are multiple inventors in an application, what is the rights of each of them within that group? So in the US Act, all of them have equal and undivided rights. So also in Europe, so also in India. Okay. So what happens is, whether you are the first inventor, you're the second, you're named the last, you have contributed only to one claim, or you contributed to all the claims in the invention, your name appeared, somewhere in between, or your name appeared up front, you were the first, or your name appeared in the fag end of the list, it really does not matter, because all of the inventors enjoy equal and undivided rights, which can be assigned, right? So therefore, the inventor list is only critical with regard to you determining who has contributed to the conceptualization of the invention. It really doesn't matter in what order it flows. Okay. However, there is a difference between the Indian and the US Act when it comes to further enforcing your rights. Okay. In the US, there is no need to obtain each inventor's consent for licensing agreements or for practicing the invention. This is very key to understand. Okay. So if there have been 3 inventors, and two agreed to license it to a certain entity, they can go ahead and do it. They need not have to wait for the third entity's approval. Okay. So this is very, very crucial. Okay. Please remember that you don't have to take the consent of each inventor for licensing agreements. Okay. However, in Europe, you do need, most of the countries, they do need, and in India also, the approval of each and every inventor is required, and only then you can carry out assignment or other licensing agreement. Okay. So in that sense, the rights vary a little between the US and the Indian and the European counterparts. And there is one case law actually around this particular clause in the US, and I'll take this opportunity to have the discussion with you. Thanks to some of the notes, inventor guidance notes that was prepared a few years back in CSR NCA. I could refer to this particular case, and I found it extremely interesting. I thought this is the right moment to share it with all of you. There was this particular invention that was conducted by certain university scholars. Okay, there were 3 of them who conducted the invention, and when they applied for the patent, okay, there were only 2 names included. And so only A and B applied for the patent, and C got left out. Okay. Then there was, the licensing of the patent, and A and B licensed it to a company called Monsanto. This is particularly basically in the agricultural space, and A and B assigned their rights, licensed their rights to Monsanto, and Monsanto started practicing the invention. So one of their chief competitors in that particular space in agricultural sciences was a company called Aventis. And when Aventis looked at this technology, they realized that if they were to practice it, they would obviously be infringing Monsanto's rights, and they would be sued for it. So the question of going into the market without a license from Monsanto did not exist at all. What Aventis then did is they started digging around a bit, and they found that there was person C who was also involved in this particular invention and who was not named as an inventor. So they supported C in getting his name acknowledged as an inventor in the particular patent. So C went and fought for his rights. The patent office and the courts acknowledged the fact that C is a true and first inventor. He's a co-inventor to that particular invention, and his name should be included. And then C, signed a licensing agreement with Aventis, and thus with just C's, approval, Aventis got rights over that invention, which otherwise it would have had to go to Monsanto for licensing. So, commercially, this was a big blow to Monsanto's strategy of getting that patent license for their marketing and, for their particular business strategy. So it can be a big blow if you did not take cognizance of the fact that all A, B, and C were basically inventors of this particular patent application. So, because in the US system, you don't need the approval of each of the inventor, therefore A and B could license it to Monsanto. And for the same reason, C could also license it to Aventis without the permission of A and B. So this is something one needs to be really careful about. So moving on further.
Srividya, there were two more questions in the chat
Sure.
box. Should we take them?
Sure. Yeah.
Okay, so there's one from Ravi Ram. He's saying, in the Indian system, can a company initiating a sponsored research project that is simply funding it, not conceptualizing it, claim the right for the IPs as inventor or as owner?
So what are they doing? They are merely funding the research.
Yeah, funding it and not conceptualizing it.
Okay. So if the collaborators are not conceptualizing the invention, then they will certainly neither, in any case, if it is an entity, it cannot be an inventor. An inventor will only be a natural person. And since they are not involved in the conceptualization of the invention, they cannot be named as a true and first inventor. However, if there is an agreement between the two parties and they want to name each other as co-applicants, or they want to be the sole applicant, whatever is the terms and conditions in the agreement, they can go ahead with that. The applicant, they can certainly be. Inventor, certainly not.
Okay, there's one more from Jasveer. Are the rights of inventors and applicants same or different?
See, if the inventor is also the applicant, then they have the rights of the patentee as I listed. I'm talking of the Indian scenario. The rights of the patentee, or the applicant or assignee, is the rights of preventing others from making, selling, offering for sale, using or importing the invention. That is the rights of the patentee. The patentee could be the inventor himself or the applicant, right? So that is the right of the patentee. Now, when it comes to the right of the inventors, it depends on the scenario that you're in, because if you're an employee and you have an agreement with your organization that you will be named an inventor in a patent application, but you will write off the rights to your company, then that is how it will be. Similarly, if you are, working in an, say, a research institute or a university, and your employment agreement states that you will be named a true and first inventor if you conceptualize the invention. However, the rights that is the patentee's rights, are to be assigned or assigned to the university, then the rights will rest with the university.
There's one more from Archana. She wants
Yeah.
to know, do we need consent of inventors while licensing or assigning the patent in India? Even if all the inventors have assigned their respective rights in the patent to applicant in Form 1 at the time of filing patent application.
Right, then you don't need, because the inventors have very clearly declared that they are assigning their rights to the applicant. So you really don't need each inventor's consent if you're further licensing or assigning the patent rights.
Okay. Vidula is asking, how is inventorship decided in collaborative research? Agreement terms may be of importance in this case then.
Yes, agreement terms will be important, but even there, if your collaborator, as I said, is merely contributing commercially to the invention, or whether the collaborator is also involved in the conceptualization. So when you are having an agreement with your collaborator, it is it will well worthy to look at the clauses to see how these things are defined, whether the distinction between inventorship and assignee or applicant is very clearly laid down. And with regard to how we have now seen who an inventor is, whether it is in line with those requirements. So vetting of that agreement from these aspects would be crucial for determination of inventorship.
Yeah. Okay, we can move on.
Yeah. All right. Okay. So while we do not have really a test for inventorship, and we'll have to conceive one by ourselves, however, there can be penalties if you have incorrectly named inventors. Okay. This just makes me remember one of the incidences that took place in my own organization, the law firm where I work, in my very early days. Okay. So there was this particular patent application where there were four inventors named, and one of them was actually uh, a newly joined employee of the organization. He left that organization, after the patent application was filed, and then he actually was not traceable. Okay, while his name and address and everything was available with the company, they could not trace him. And then eventually, the company had a very tough time, because you need the consent of all the inventors if you have to further, conduct these the proceedings. So even when you are applying for the patent, when you are listing the names in the form 1, you need their signatures. And if you're not able to trace someone at that stage itself, okay, then it is only right for you to go back to the drawing board and decide whether to have him as an inventor or not, and what is the risk you're undertaking. Okay. See, there can be the risk of, as put in this particular slide, the penalties for not including a particular inventor's name. On the other hand, if you have to license the technology and your documents are not clear, okay, you have not filed the form 1 with the required number of all the inventors names, there is something missing there, or your form 1 was faulty, you went back and filed another one later at the patent office and you missed that person's name, so you have two on the record there. Such kind of situations do happen. So it is very, very important that you decide who your inventors are. The employment terms and conditions are adequately having the safeguards, so that you don't land yourself in such kind of situations, or you don't have issues when you have to eventually commercialize or license your technology, patent the technology. So please ensure that when you're doing your inventor list, you're doing the required homework, other than just determining who is the inventor. There is a lot of paperwork, there are a lot of documentation that is involved in the process of patenting. So moving on further, what are the penalties? Basically, if you look at the Indian scenario, then a patent can be opposed both pre-grant or post-grant, and or revoked also, on the ground that there is wrongful obtainment. Okay, so if so you have section 25(1), 2 and section 64, and just for your knowledge, I've actually kept it ready to read it out to you. And what the particular clause says is that the applicant for the patent or the person under or through whom he claims wrongfully obtained the invention or any part thereof from him or from a person under or through whom he claims. So what you're basically saying is if there is a wrongful obtainment of patent rights, the true and first inventors are not named there, then it can be a ground for opposing or a ground for revoking the patent rights. So this is, the penalty that you pay if you do not have correctly named inventors in the patent application. A patent may also stand amended in the name of the opponent. Okay, so what happens in the opposition proceeding is that there will be an amendment, the opponent's name will get included, or it may even go alone to the opponent. Okay, so it's okay if the opponent's name is included in the list of inventors. So then the rights are still across all the other inventors. However, if it goes into the favor of the opponent alone, then the other inventors have lost their rights because they did not include his name in the particular patent application. And over and above, if there has been an amendment to the specification and demanded because of the change in the inventorship, then there could be an addition or a removal of certain portions of the patent specification as well. In the US and EP, it's far more severe. So the patent is just declared invalid. That's more so in the EP. However, in the US, the court may order for a change in the inventorship also. So they will actually, order the applicant, the assignee, sorry, or the inventors to actually redeclare the inventor list, and then accordingly it will be recorded in their books. So there are penalties, there are safeguards for in favor of the inventors within the statute itself. So coming to the section where I said we will try and derive a test which is for determining inventorship. This has been actually followed to some extent in CSR NCL. They actually had a system designed in-house. Credit to that. I acknowledge that, though I've not put it down here, I would want to acknowledge that part. And they had the system where they would do what is called a claim analysis and determine who had contributed to the invention. So of course, the basic details were there, like who's the organization, the principal investigator's name and contact details, the title of the invention, whatever is the internal in-house reference number, date, and so on and so forth. But let's come to the way in which the inventorship is determined. Okay, so this is basically an invention where you had three main claims, or what are called the independent claims. There were several dependent claims, but you had a claim to a composition, a process of making the composition, and a device, which is made from that particular composition. So these were the three main claims, and there were several people who were involved. Okay, there were students, there were lab assistants, there were a testing laboratory that was involved, and an analyst particularly there, and then there were some postdoc fellows who were there, and so many, so on and so forth. Okay, so you basically had X, Y, Z, A, B, E, G, J, K, and L. Okay, all these people were there, and each had a different, profile in terms of their position in the particular organization. So X was the principal investigator. Of course, he was the one who conceptualized the entire invention, and he was therefore naturally in the inventor list. Y and Z were students, okay, who would actually follow the protocols or the orders given by X, and they would conduct the experiments. So they were basically the people who were reducing the conception of the invention to practice. The invention that was conceived by X was reduced to practice by Y and Z in terms of the preparation of the composition. Okay, in terms of the composition itself. Okay, the entities who were involved were Y and Z as students, and G was their lab assistant who would actually set up the experiment and who would ensure that all the equipments are available, the testing, all the glassware is available, and so on and so forth. Okay, now you also have A, C, and G. Okay, now A and C are again students, However, when it comes to, A and C are students, but when it comes to C, what had happened with C is that, he had contributed to a particular dependent claim. Okay, so in the composition, there were 3 or 4 ingredients, and one of the ingredients, okay, which was key to the composition was actually conceptualized by C. And amongst the choice of those various options for that particular ingredient that C had conceptualized, A had contributed to one of them. Okay, so amongst the various options that could possibly work, A had, kind of given his intellectual contribution with regard to which would be the best possible, choice among the options that they had derived. Okay, so this was how the composition claim was, actually conceived and reduced to practice. So therefore, you have X, A, and C as the inventors for the first claim. Okay, so you have, those. It's very clear that you have taken the first claim, you have dissected it, you have decided who played which role. Okay, who were part of the intellectual contribution, who were part of reduction to practice, what was their role in that term, and in that sense, and you have decided who are the true intellectual contributors and listed out the inventors for claim 1. You similarly did an exercise with the process claim and with the device claim. So in the process claim, Z was a lab assistant, similar to the one in the first claim. So he continued to play the same role and therefore was not qualified to be an inventor. Now there was an entity called B here, who was basically an analyst in the testing laboratory. Okay, so he was the analyst who would actually get the samples for testing. He would run it through the various instruments, and whatever results are obtained, he would hand it over to X and his team. So he was basically an analyst who would be running the samples that are provided to him. Since he did not have an intellectual contribution at this stage, so both Z and B were out of the list. Only X and E. E had an intellectual contribution to the process of making, and therefore these two proceeded to be the inventors of the second claim. Similarly, with regard to the device, okay, you had J and K, who were postdoc fellows, who scholars who were well versed in this field, and were actually the ones who conceptualized the fact that this composition can be used in this particular device. It was under their suggestion that this device was actually made with the composition of the first claim which X had conceived. And L was a student, sorry, not X, but L was a student. And X was the same as in, the first and the second claim. And he carried forward his discussions with his postdoc fellows and was also involved in and he anyways was involved in the composition. So he was also involved in tweaking the composition to the extent that is required to fit into the device that, L and K, J and K had conceived. Okay, so therefore your inventor list is now A, X, C, E, and J and K. Nobody else would be part of the inventor list. So they are joint inventors. They all belong to the same applicant in this particular case, but they were doing different functions. They were performing different roles in the reduction of practice of the invention. However, since only these people, contributed to them intellectually, therefore they would be named as inventors. So this is one of the best ways to determine. This is part of good practices in intellectual property cell, where you actually record each contributor's contribution, what have they contributed to, and therefore arrive at an inventor list. And you have this as a support to the fact that for each patent application, why you would have XYZ as the inventors. Okay, so moving on further, there are certain other considerations when it comes to inventors, which one should just keep in mind. One of them is with regard to anticipation. Anticipation is basically any document which anticipates the invention or destroys its novelty. And one of the aspects here is why it has been clubbed with inventorship is because in the Indian Patent Act, it clearly says that if the true and first inventor reads a paper or basically publishes a paper in front of a learned society, then it is not considered to be an anticipating document if there is a patent application filed within 1 year. Now, there is a little gray area here because this is not very severely enforced as it is put down in that particular section. But a true and first inventor is usually involved in creating a prior art for his own patent application if he reads the paper in front of a learned society. So, in that sense, you have a possibility that a true and first inventor could come into the picture here if he has read a paper or if he has published a paper. The second aspect is if you have, your patent application has undergone several claim amendments, you dropped out some claims, or your patent application has been divided, okay, and you have divisional patent applications filed, there could be a change in the inventor list. This is particularly very relevant if you're doing an election restriction kind of office action in the USPTO. In fact, when you are issued that kind of communication from US patent office, they actually tell you to relook the inventor list when you're doing an election. So if you're opting for a particular claim and one of the inventors needs to be dropped out of it, of course, based on the kind of analysis we did in the earlier slide, then you should be writing that back to the patent office. And that is obligatory on the patentee or the applicant to do it. The patent office is not involved in determining who is the inventor or who owns joint inventorship or who is claimed, participated or contributed how much in terms of intellectual inputs in each and every claim. They do not determine inventorship. They will not come into your process of determining who should be the inventors. They will just receive the document from you with regard to the declaration of inventorship and publish it as such. All these homework has to be done at the applicant or the assignee stage itself. Okay. Similarly, as we saw earlier in licensing and assigning agreements, inventors play a crucial role. Okay. The applicant, if the inventor is also the applicant, then the rights basically rest with the inventor then. And if there is a share in rewards, as we saw earlier, there are many organizations which say that if there is a commercialization of a patented technology, then there will be a share in the rewards. So, naming the correct inventor and that person, getting credit for his intellectual contribution as well as getting a share in the rewards is very crucial. And if there is opposition or a revocation, then you lose rights, and therefore the inventorship is also lost in the process. So these are just certain considerations which I wanted to bring to your attention. And of course, nowadays, nothing concludes without bringing in artificial intelligence, and that is true in the case of inventorship also. So we fortunately already have a case law. Okay, there has been this Dr. Thaler who came up with this device and method for the autonomous bootstrapping of unified sentience, in which he named only AI as an inventor. Okay, he filed few patent applications and they've all been rejected, even though they satisfied patentability criteria. They have been rejected by the national patent offices since you cannot name AI as an inventor. And at this stage, okay, where there are patent applications being filed with AI as a co-inventor in some, okay, and we really do not have too much to go by. There are only more questions than there are answers. I have tried to raise a few of them in this slide. I don't really have answers to all of them. And all I've tried to do is to stimulate your thinking. Okay, I have no comments to make. I'm only going to read them out to you, or you can do it yourself, of course, because we don't have the statutes in place as of now. We don't have laws. The World Intellectual Property Organization is still working on determining how you can deal with these kind of applications. Should AI be acknowledged as an inventor? Does it go against the concept of the classic definition of an inventor? All this time we kept on saying that the inventor is a legal person, the inventor is a natural person. The true and first inventor is always a natural person who contributes through his creativity, through his ingenuity, through his imagination. Now, if we had to define an inventor like that, then how does AI fit into that particular definition? Because there is no person at all involved here. So can a non-person be an inventor? That is the first question. And if you're talking of determination of inventor step, then who is a person skilled in the art? AI is the inventor, then who is the person skilled in the particular art? So whom do you compare it with? That is the next question. And can you say that the machine is that particular person? That is the third question. And then if you were an inventor, you engage AI, you come up with an invention, but you file it in your name because you cannot file it in AI's name. That means you are basically owning the inventor here. So then the question is, who is the creator? You are certainly not the creator. You are certainly not the inventor. It is AI which is the inventor, and you are actually owning that particular inventor. So is there an ownership of inventor allowed? I really don't know. We don't have answers to this. So can there be a natural person and AI as co-inventor in a patent application? Yeah, will that kind of scenario be allowed? Okay. So if the inventor is a deviser of the invention, then the applicant should recognize that, which is what we have been telling all along, right? So if there is a university or an industry and its employee has come up with an invention, then that particular inventor needs to be recognized for his creative input. So here there is no such natural person to be recognized. And then if you say that the inventor is a person who defines a problem, he conceptualizes the solution, then we are talking of creativity, and we are not just merely talking of ownership. So who owns the rights, who owns the inventor, who owns the rights of the inventor, all this comes much later. When you're talking of inventorship, the bottom line is it is creativity which is involved, and it is the creator who should be named as the inventor or the joint inventor. So with this, I conclude my talk. I'm open to any more questions that you may have. Over to you, Mumta.
Yeah, thanks, Srividya, for summing it up so beautifully. It's a huge topic. Before we take on the last few questions, let me remind everyone the feedback link is in the chat box. So please do give your feedback if you plan to leave the session before we are closing on the questions. The second thing is the sessions are available on the YouTube channel of techix.in. The current session and also the previous sessions in this series. So you can go to the YouTube link, which is also there pasted in the chat box. Moving on to the last few questions.
Yeah.
Amita wants to know, in case of publication that where only part of the invention is disclosed, could be novelty killing document in case of patent application filed within 1 year of publication. So is that the case?
In case of publication in reputed journal, only few paragraphs, could it be an novelty-killing document in case of patent application within 1 year? See, Amita, this is actually a statute or part of the law only in India and US, okay, that you publish in a reputed journal. Well, I wouldn't even say reputed journal because the Indian Act says learned society. Learned society is not really defined in the Act, and I wouldn't want to go by its definition from any other source. So it could be any journal, and if you have disclosed that part of the invention which is crucial, then that document will certainly be novelty killing. However, this filing within a year, or what is called the grace period filing, is available only in India and US. So if you were to seek patent protection in other geographies, then you will have to look at the patent laws in those countries. I think Japan had 1 year, but they reduced it to 6 months. And certain geographies are very clear that they do not give any grace period provisions at all. So you will have to be careful. You'll have to, if you want to seek patent protection in those countries which do not give grace period provisions. But yes, if a substantial part of your invention was published in that reputed journal, it would be a novelty killing document.
Okay, thanks. Srividya, I assume you have 5 more minutes. There are 1 or 2 more questions in the chat.
Sure. Yeah.
So Bipin wants to know, he's built a scenario. If A licenses a patent to B and B builds further on the technology, does B need to take A's permission to do so? Can B then license the added technology to C? Is this possibility usually part of a licensing agreement?
Okay. Now this is a little complex, Bipin, and you're looking at now what are your terms and conditions in the license? What was agreed upon will have to be understood first of all. Okay. Usually, background IP and IP is developed further, okay, is covered in agreements. Because we all know science is progressing, there could always be new things that can be added up, and how to deal with them, how to further ensure that all the stakeholders' rights and their privileges are maintained. This will completely depend on the clauses that is there in the licensing agreement. Okay, so if you do not want B to further develop the technology without A being part of it, then A and B, A has to ensure that that is part of the technology. But on a more one more critical aspect that one needs to also understand here is whatever B is building further. Okay, now if he is giving it to C to commercialize, okay, now if will C be able to commercialize that without um, infringing A's technology? Okay, so there is also an infringement aspect that comes into it. Okay, whether B giving such a license to C is covered in that particular agreement between A and B, which ensures that C is not infringing that particular patent that is licensed to B. So all these will also have to be considered. So I really don't have a ready-made answer. All I can say is if you are considering these kind of scenarios, then your agreement will have to consider all these and you'll have to build clauses in the agreement itself.
Yeah, so the agreement drafting has to be done really carefully.
Right.
Yeah. Ravi Ram wants to know, is there any specific requirement in terms of maintenance of lab notebooks, e-documents for claiming inventorship? What are mandated or required?
Yeah, so Raviram, what I would like to say here is, see, as I told you, the patent office is not going to come and look at who conceived the invention, when did it happen, who thought of an idea, who thought of the idea, then who reduced it to practice. They are not going to get into any of this. Okay, for them, the document that they receive with the names and details put in those particular forms that are filed is what is important. So the patent office is never going to look into it. But as I told you, the case between Monsanto and Aventis. Okay. Now, the entity who eventually, the inventor who went to Aventis, did have documentary evidence to show that he was an inventor in that particular patented technology. Okay. It is only on the basis of that that Aventis supported him and they could approach the USPTO, and the USPTO also acknowledged the fact that that particular person C was a co-inventor in that particular patented technology. So the documents and the records, whether they are e-records or whether they are physical records, whether they are lab notebooks or you have other means of maintaining records, whatever means, they are mandated or required because for the 20 years for which your patent rights are in force, your rights can be revoked at any point of time. And it is these supporting documents which will come in use to you when you have such kind of legal proceedings filed against you. So for that reason, all records are mandated and required. So you have a further question which says it's better to file first and then only publish, communicate to any other. Yeah, that is a golden rule. First, patent first and publish only later. Okay, so that is a golden rule, absolutely the golden rule. No, better not to deviate from that, because then you're not limited by the fact that you already put out a novelty killing document in the public domain. So always file first and then only publish.
Yeah. Thanks, Srividya, for also taking up all the questions. We took up a little bit more time, but thank you once again for your support.
All right.
Yeah, so let me announce the next upcoming session, which is going to happen on 26th of March, which is also Tuesday. So two Tuesdays from today. The session is going to be taken by Mr. Vivek Sadle, and it is going to be focused on only sale and purchase agreements for mergers and acquisitions. So another interesting topic coming up. You need not sign up again. So the same sign-in will work for people who have already signed up. And please do share details of this series with your networks and connects if you think they will benefit from this series. Thank you once again, everyone. And thank you, Srividya, for this session.
Thank you so much, Venture Center and Bugda. Bye-bye to all of you.
Yeah, bye. Thank you.
Yeah.